Good afternoon, everybody. Welcome to the webinar on PD rights. We're just going to take a couple of minutes where we're going to talk amongst ourselves whilst everybody logs on and gets into the room, so to speak. Zach, are you actually wearing a full suit? Or is it just
it's a jacket. It's not a full. I thought the top half was the really important bit to look smart for this evening. Yeah, I've gone further than shorts though.
For this special occasion.
For this very special webinar, absolutely. Pulled every stop out.
Excellent. Right. Can anyone see numbers for me? Is it still going up? Should we hold on for a little bit longer? Yeah. Okay. Should we make a start? So, good afternoon proper. Well, it's just about afternoon, I think. Outside, so that doesn't feel quite right to say. But welcome to this webinar, Legal and Landmark Chambers. Today's session is all about permitted development rights, or the PDRs that came into force earlier this year that enable new dwellings to be created, either by extending existing buildings upwards or replacing existing commercial buildings with resi units. So before we get properly stuck in, I ought to introduce the panel. My brilliant and learned panel for this evening is in order to help us understand these new PDRs, to talk about some of the main issues that they raise and perhaps what's in our future as regards more PDRs, are starting once again with Simon Ricketts, my brilliant fellow partner at Town Legal. Say hello, Simon, or waving. Yeah, that would do as well. Moving on to the always energetic Zach Simons from Landmark Chambers, and his ever-changing lockdown beard. Say hello, Zach.
Good evening, Mita.
If you've watched any of our previous webinars, you'll know that that Simon and Zach are old lags. They're old hands at this webinar malarkey. But today we've got a new face in the form of the brilliant and quirky, and indeed brilliantly quirky, Victoria McKeegan, Senior Associate at Town. Say hello, Victoria.
Hi, Mita.
Excellent. So to finish off the introductions, I am your chair, Mita Call, also a partner at Town Legal. So a few housekeeping points to note. Your microphones are automatically muted, so please don't feel you have to fiddle with any of your own settings. We do welcome questions, and indeed this is intended to be a bit of a question time session, so do submit them in the Q&A on the screen. But I have to say that in the interest of managing expectations and in the interest of transparency, I need to warn you that due to our huge surprise, actually, we received so many questions in the run-up to today that we may not get to the ones that you're posing on the screen during this session, but we will try anyway. Finally, if you lose your connection at any point, then just use the same link to get back into the session. Right, time to crack on. So we've only got an hour. For various reasons, we may run over slightly, but we will try not to. So PDRs, why now? Why are we having a session on these PDRs now? Well, apart from the fact that the summer left you thinking that PDRs were a bit like buses, when we first started thinking about this session, it was originally because we thought, well, PDRs have had a few months to bed in for people to get their heads around them. And let's not beat around the bush, they're not easy. There is a significant amount of conditionality, which really has had a lot of people wondering about, you know, how useful are they actually? But there'd been the challenge to the PDRs by rights community action, and that challenge was ultimately unsuccessful. And so any uncertainty surrounding whether those PDRs would basically survive to see the new year, that had been removed. And then, although we most definitely cannot lay claims to having any insider information at all, on the 3rd of December, of course, the government very kindly dropped another consultation paper on us, supporting housing delivery and public service infrastructure. There are a number of proposals in that paper. but of particular relevance and interest for today's session is the proposal to introduce yet another national permitted development right. This time, change of use from the new Class E, introduced in the big shake-up of the use classes order earlier this year to residential. So arguably, alongside the changes to the use classes order, this is actually far more radical than anything else we've seen this year, including, dare I say it, the planning white paper proposals. In this session, we're going to centre our discussion around two main areas, or two baskets of issues, if you like, in relation to the existing PDRs, and then spend some time on the proposals in the most recent consultation paper. So on this basis, it seems only right that in time-honoured fashion that we start our discussion about the new PDRs by a description of what they are. So Victoria, can I hand over to you for 5 minutes of the proverbial nuts and bolts bit?
Of course, thanks, Mita. Well, that's easy. It's A, AA, AB, AC, AD, ZA, E equals C3, adequate natural light, and minimum space standards. Simple. 2020 has been a year of many things, and one of them is the PD right. As well as remembering hands, face, space, those of us in the planning world have been faced with a barrage of new letters to commit to memory. I've been thinking along the lines of Mercedes cars, batteries, a famous rock band, and an equestrian Olympian member of the royal family, if that helps. This year, it feels as though no sooner has the ink dried on one set of amendments to the General Permitted Development Order than the parliamentary draftsmen have been industriously penning the next round. The order has undoubtedly become a weightier tome throughout the year, as even deregulation requires legislation. The direction of travel has been upwards, the race to space for new dwelling houses seen in the skies. So for the purposes of this webinar, as Mita says, we're talking PD rights for new dwellings, and going slightly off-piste based on our original marketing, because we couldn't resist it, the recently announced consultation on E to C3. 4 rounds of legislative amendments to the GPDO are relevant. There have been more, and the ideas stem from the government's 2018 consultation on supporting the high street and increasing the delivery of new homes. So here goes. Stay alert, the government said in May. In June came the introduction of a new Class A, in a new Part 20, permitting the construction of up to 2 additional stories of new flats immediately above the topmost residential story of a purpose-built detached block of flats. In addition, the regs introduced a new requirement for the provision of adequate natural light in all habitable rooms where PD rights are exercised, both for changes of use to housing, as well as for the creation of housing via the new upward extension rights. This becomes a matter of prior approval. The government wasn't messing around. These new rights came into force on the 1st of August. The government described the measure as being necessary to support key government priorities and national policy to boost housing and increase densities by making effective use of existing buildings and avoiding the need to develop greenfield sites. It also formed part of the government's COVID-19 economic renewal package by enabling new homes to be delivered more easily. As for adequate natural light, that's a nod towards the criticism levelled at the existing Office to Resi PD right for leading to the creation of dark windowless homes. No longer will a former photocopying room be repurposed as a des res, the government says. This was not all, however. Barely a month later, in those heady days after pubs and hair salons had reopened, a further package of new upward extension rights were introduced, coming into force at the end of August. These introduced 5 new classes, Class AA in Part 1 and classes AA to AD in the new Part 20, permitting the upward extension of existing homes and allowing existing buildings in various uses to be extended upwards to create new flats. Perhaps of most interest are classes AA and AB, which allow, in the case of a detached building in use as one or a mix of commercial uses, or any of these uses plus housing, up to 2 additional stories of new flats. For terrace buildings in such uses, 2 additional stories are permitted. For buildings of 2 stories or more, or 1 for 1 story or more. 1 story, sorry. There are various commonalities between the new upward extension PD rights. All of the rights to extend upwards to create additional flats apply to buildings built since 1st of July 1948, being those granted planning title under the current planning system introduced by the TCPA 1947, and before the 5th of March 2018, when the intention to introduce a permitted right to build upwards was first announced. Houses or buildings must have been in one of the relevant uses or mixed uses on the 5th of March 2018. The rights do not apply to listed buildings or to buildings in conservation areas or other protected areas, and there are various restrictions in terms of the height of the original building, the height of the building as extended, and floor to ceiling heights in respect of the new stories. So the conditions need to be read very carefully. The new rights are subject to obtaining prior approval from the LPA in respect of various matters, such as the external appearance and the impact on the amenity of neighbouring premises. In respect of existing commercial buildings, the impacts on the introduction of or an increase in the residential use of premises in the area, on the carrying on of any trade, business or other use of land in that area is also subject to prior approval. The list is lengthy, which has led some to suggest that the prior approval process is a pseudo-planning application. More on that later. On the same day as introducing the preceding batch of upward extension rights, the government also introduced perhaps the most radical measure in the suite, down then up, in the form of a right allowing for the demolition of vacant and redundant residential and commercial freestanding buildings built prior to the 1st of January 1990 and their replacement with a new detached dwelling house or block of flats. This is the new class ZA, and it came into force on the 31st of August. It applies to buildings which on the 12th of March 2020 either fell within Class B or were purpose-built residential blocks of flats in Class C3. The buildings must have been entirely vacant for at least 6 full months prior to the date of the application for prior approval, and the right is restricted to redevelopment of a single new building within the footprint of the existing building, that footprint being up to 1,000 square metres. A further 2 stories are permitted, subject to height restrictions. Again, the list of matters requiring prior approval is lengthy, covering many of the same matters, but also adding matters such as the design of the new building, landscaping, and the impact on heritage and archaeology. Having seen the light in June, in November, the government found some space. A further set of amendments were introduced requiring new homes created through PD rights to meet the government's minimum space standards published in 2015. All such homes will need to be no smaller than 37 square metres as from April 2021. Tennis is my thing, and that's about 1/7 of the size of a doubles tennis court. Interesting. Again, a measure seeking to address the allegedly poor quality of certain homes constructed pursuant to existing PD rights. And finally, and yet to find its way onto the statute books, is the government's announcement earlier this month of a proposed PD right, as Mita says, including the conversion of Class E to C3. I'll be covering that in more detail later. So the scene is set. In short, we're moving on up. Back to Mita.
Thanks, Victoria. Brilliant. Thanks for putting us all in the picture. I think that's oriented us basically on our main subject matter. So now we're going to move on to the first of our main topic areas, and it is an area or a bucket of issues really, but it sort of centres or starts certainly on prior approval. So as Victoria's already talked about, one of the big issues with the new PDRs is the number of prior approval matters that now fall to be dealt with. We've got a longer list. They cover issues that are arguably pretty subjective. And as you said, Victoria, possibly make the whole process bear a remarkable resemblance to putting in what we possibly consider to be a full planning application, but possibly also undermine some of the certainty that the government, I think, was trying to achieve with PDRs, or certainly that's what it says it's trying to do. So what can the local planning authority have regard to when it's considering prior approval applications, and how should it properly go about making its decisions? Zach, you're the lucky person that gets to deal with that rather tricky issue.
Thank you, Mita. Yes, a tricky issue it is. It's one really interesting feature of the onward march of PD rights that Victoria's described is the growing importance of the prior approval procedure, what it covers, how it works, the number and complexity of its conditions. We've heard a bit about that already. The scale and the scope of the developments it can permit. It might have started life as a relatively modest procedure to approve things like the siting of agricultural barns, but we're a world away from that now. It's fully entered the limelight as a really important mechanism, which has the power to permit substantial new pieces of development in prominent locations. But what actually is it? Or to put the question a little bit more precisely, how is an application for prior approval any different from an application for planning permission? And do the differences matter? Well, to start with, just a couple of legal headlines to get us off on the right track. The Town and Country Planning Act allows planning permission to be granted in a number of ways. 2 of them are by development order and by local authorities on application. Now, either route can, of course, be subject to conditions. Some of those grants of permission by development order are conditional, on prior approval, which is defined in 69A of the Town and Country Planning Act. So just to start at the very beginning, the statutory scheme treats prior approval applications separately from applications for planning permission. That isn't always obvious because they're both applications, both relate to planning matters, but only one is a planning application. Now, that there are two different routes to planning permission in play here is actually important because they're subject to different decision-making duties. What does that mean? Well, applications for planning permission, but not for prior approval, have to be taken in accordance with the statutory development plan and other material considerations, as we all know. Not so for prior approval applications. For those, the permission's already been granted. It's been granted by the GPDO itself. The prior approval application is effectively an application to discharge conditions which pertain to that PD right. So we don't go back to section 38.6 or to section 70 of the 1990 Act. The scope of issues which is material to our prior approval application is fixed, and it's fixed exclusively by the terms of the GPDO. There's not any freestanding requirement to think about the development plan or other material considerations more generally, or even the MPPF, unless, of course, the GPDO tells us to think about the MPPF, and I'll come back to that in a mo. Now, all of that might seem pretty simple in the case of, let's say, an agricultural building prior approval, which under Part 6 in the schedule to the GPDO, prior approval is required in respect of siting, design, and external appearance of the building. We know that's a closed list. See the Keenan case in the Court of Appeal in 2018. So far, so straightforward, you might think. Well, probably most of the time, albeit only last week, I've fended off a judicial review challenge where the claimant had alleged that a council had failed to consider the impact of my client's new agricultural PD building on the setting of a nearby listed manor house. Were any heritage impacts, such as there were, material to the prior approval? How do heritage impacts, for example, fit into that rubric of siting, design, and external appearance, if at all? Well, how about the Listed Buildings Act? But Section 66 of the Listed Buildings Act specifically applies to planning applications, not to prior approval applications. So what about the heritage chapter of the MPPF? Tricky, because we know from the Mordew case in the Court of Appeal that the heritage chapter in the MPPF corresponds to the duties under Section 66 of the Listed Buildings Act. And we also know that paragraphs like 195 and 196 require balancing of a scheme's public benefits against any heritage harms, which we know is not supposed to be the function of a prior approval application. So what does that mean when it comes to, say, the siting of an agricultural building in the setting of a listed building? Is there literally no obligation to have regard to any impact on the historic interest of that building? Well, we'll see. The claimant's going to have a go at getting the Court of Appeal interested in that case, so I won't comment on it any further. But for most other forms of prior approval, things are actually much more complicated than the simple rights which pertain to agricultural buildings. And that's for two big reasons. The first is the as-if clause, and the second is the scale and scope of PD rights conditionality. So first, what is the as-if clause? Well, for lots of PD rights, including the new Part 20 rights that Victoria summarised a few minutes ago, we're told that the LPA has to, when it's determining applications for prior approval, have regard to the MPPF, so far as relevant to the subject matter of the prior approval, as if the application were a planning application. As if. Now, what does that actually mean? When, as I've said, they aren't planning applications, so far as relevant. What does that mean? Does that mean that we think about some bits of the MPPF, but not other bits? And if so, how do we work out which bits we're lawfully entitled to look at when we know that the whole of the MPPF is supposed to be a kind of composite expression of the government's view of what sustainable development means? That as-if clause is, I fear, a bit of a High Court challenge waiting to happen, and it's remarkable in a way that hasn't happened already. But it opens up, I think, Pandora's box of the issues that prior approvals might be able to cover. And what about the nature and scope of that conditionality? Let's take as an example one of the classes that Victoria mentioned in her introduction, that class AA in the new Part 20, one of the much discussed suite of new provisions that allow building up by 2 additional stories. What does the prior approval need to cover for such a class? Well, it's 10 different things, which I will not read out, but they include issues that just might get a little bit complicated and contentious, like transport and highways impacts, the external appearance of the building, including design and architectural features of certain elevations, adequate natural light in habitable rooms, impact on amenity of the existing building and neighbouring premises, including overlooking privacy, loss of light, and the impact of more residential development on local trades or businesses. I mean, if you're going to have to cover all of that stuff anyway, and the NPPF applies to just as if it were a planning application, which it's not, why not? You might be asking yourself, just whack in a full planning application and be done with it. And each of those conditions is actually more complicated than it seems at first blush. And that's partly because of the nature of prior approval applications. The government has, in effect, taken development management criteria out of planning policy and put it into law, into a statutory instrument. And that creates some challenges, because whether or not there is, take as an example, adequate natural light in habitable rooms, it's normally a matter of evaluative judgment under the auspices of amenity policies in a local plan. Well, all of a sudden, that's a question of law, which means it has to have a correct legal answer, but heavens knows how we're going to go about working out what that answer actually is, because to just run with that natural light example, the standard text tends to be Paul Littlefair's BRE guidance, site layout planning for daylight and sunlight. But that guidance tells us in terms that it's not mandatory, it needs to be interpreted flexibly, shouldn't be seen as an instrument of planning policy, still less some kind of crib sheet for determining legal compliance. Take another apparently innocuous example, the external appearance of the building. Well, you might think that's straightforward enough, isn't it? Look at the building, assess the elevation plans, reach a judgment. But a judgment on what? Just the building itself? The whole thing? Just the 2 new stories? Any architect will tell you that good design can't be judged in a vacuum. Buildings are appreciated in their context, in their townscape. So what if that external appearance is said to harm the character of that local townscape? What if it's said to clash with local vernacular, or the setting of a listed building, or the setting of a conservation area? What then? Are we into a broader townscape assessment, conservation area appraisals, listed building studies, visual impact assessments? And remember that as if clause. If we really are supposed to be thinking about all of these difficult and more wide-ranging issues, then the policies in the NPPF apply to those matters just as if they were part of a full planning application. And as if that's not hard enough, let me give you another fiendish example. Take the consultation right for the new Class E to residential, PD right, that Victoria's going to come back to in a few minutes in more detail. One of the ideas on offer is that prior approval will be required in conservation areas in relation to the impact of the loss of the ground floor use to residential. But impact on what? Impact on the historic interest of the conservation area, i.e. the reason it was designated as a conservation area in the first place, impact on the vitality of the conservation area, impact on other retailers, impact on local amenity, impact on character and appearance, all of the above? And if so, if it is all of the above, all of that stuff judged as if it were a planning application under the NPPF? So to take a step back from all of this, my sort of 5 headlines for you are these. First, prior approval applications are different from planning applications in lots of very important ways. Second, in particular, the general legal duties which apply to determining planning applications do not yet, anyway, apply to prior approval applications. Third, with the government's greater focus on PD comes greater weight, scope and complexity foisted onto the prior approval process. Fourth, At the moment, our statutory framework and national policy hasn't really caught up yet, which means uncertainty over how these new prior approvals are actually going to work in practice and what they can cover. Fifth, which all means in the end, unfortunately, it shouldn't surprise us too much to see the research, for example, in Planning Magazine a few weeks ago, which suggests that the take up so far and the percentage success rate so far of the new PD rights have not been very high. But we shall see. Perhaps that will change over time as people become more comfortable. And just very, very quickly, Mita, I see that there's a very interesting question that was asked of us in relation to the ability to mix and match between PD rights in a separate planning application, which covers matters not included within the PD right. That is, we could go on a whole hour just about that. Lots of my clients, the development strategy for their site involves taking matters as far as they can be taken under the PD right, then adding the final piece or pieces to the puzzle through a planning application. And that can make sense in circumstances where we assume PD rights are easier to get than a new planning permission, and that assumption might not be as safe as it once was, as I've explained. But anyway, that kind of piecemeal approach can give rise to some interesting issues. Do you always have to implement the PD right before it can form part of a fallback position to support a new planning application? It's an interesting one. What actually is the scheme you need to seek planning permission for? Say you establish residential use through PD for 100 flats, say, and then you decide to extend through a planning application for 10 more. Is it a planning application for 10 flats, or is it a planning application for 110 flats? And of course, that might matter a great deal if you're into debates about affordable housing contributions. And we've had an interesting example in the questions so far. A Class A PD right enables you to build 2 new stories, as we know, and just that, plus engineering operations, plant, and works for the construction of appropriate and safe access and egress, ... including external doors or external staircases. But not lifts. We've had several people saying not lifts, or not expressly lifts anyway, not external lifts. What if you want to include external lifts? Well, it's not mentioned. Why can't external lifts fall into the meaning of the words works for the construction of appropriate and safe access and egress? Well, I'm not sure. The list of doors and staircases does not appear to be an exclusive list. It's something we might need a High Court challenge to clarify in the end. But that's it from me for now. Thank you very much, Mita.
Thanks, Zach. Well, yeah, quite a lot of things to talk about there and think about there, I think. And as you say, not yet settled. It's early days yet. So if we just wrap up on that first set of issues and move on to our second basket of issues, which broadly speaking all come under the heading of crystallising the rights, I think. When do you know you've got your PDR in the bag, given things like transitional provisions, timescales for completion, the various conditions? So Simon, I'm handing over to you because this is your basket to delve into.
No, thanks, Mita. I tried to take a step back and look at a number of the questions that have been asked, and many of them revolve around 3 areas, all about what can restrict or take away permitted development rights. And I'm looking first of all at Article 4 directions, which are going to be absolutely key as we move forward into Class E to C3. Secondly, the role of planning conditions, and thirdly, the circumstances in which the benefit of prior approval can be lost. So Article 4, and that's probably the area where we've had most questions. So, to recap, local authority can remove the benefit of the general permitted development order in relation to particular types of development set out in the direction and in relation to either the whole of their area or parts of their area. And the process is relatively light touch in terms of 21 days publicity, copying the direction to the Secretary of State, setting the date when it shall come into effect, which can't be earlier than the expiry of that publicity period. And when the direction is confirmed, the local authority must take into account representations received. This all came, I suppose, first to the fore in the early days of office to residential, when people may remember Islington making an Article 4 direction in relation to much of their borough to seek to remove the office to residential right. There was a challenge, and in the end, there was a compromise where the Secretary of State agreed not to make a further direction when Islington made a replacement direction, which was more limited in its effect. I think we're going to go back to those sorts of issues, and we also are approaching a really key issue in terms of the timing of Article 4 directions and when they come into effect. Because as people will know, if the Article 4 direction takes effect at least a year after its confirmation, then no compensation is payable to affected landowners. Otherwise, if planning permission is refused for development, which would otherwise be automatically permitted development, or if the local authority grants it subject to limiting conditions, compensation can be payable to the landowner. Obviously, the last thing the local authority wants to be doing, and so commonly we see Article 4 directions being made that come into effect at least a year after they're confirmed. But there's a real problem here, particularly in the case of the proposed Class E to C3, because the government has said that that permitted development right is intended to come into effect on the 1st of August 2021. We do not have a year. So there are a couple of questions here. And we've had people ask, well, what about existing Article 4 directions which relate to office to residential? Do they continue to have effect in relation to Class E to residential? The answer must be, it depends on the particular Article 4 direction. And we've looked at a couple of examples. Some are specific, referring to the previous version of the General Permitted Development Order, and it's by no means sure that those orders would continue to have effect. And also, I'm by no means sure that an Article 4 direction could today be made in relation to a change to the GPDO, which has not yet taken effect. So very unlikely that a local authority could today start work on consult on an Article 4 direction in relation to this proposed permitted development right. So surely this leads to a potential hiatus where there will be prior approvals which are being sought and granted before Article 4 directions have taken effect. And there may also be a hiatus between Article 4 directions which are aimed at the previous regime and replacement directions which are aimed at the new regime. So, first main issue is that question of the timing of Article 4 directions. Second issue, in my view, is how interventionist the Secretary of State is going to be in relation to widely drawn Article 4 directions, because the knee-jerk reaction of many authorities may be to draw Article 4 directions very widely so as to seek to remove this permitted development right from many areas. Is the Secretary of State going to sit by and let that happen? We don't know. So the second main area is that of conditions, and really just to say that, as we all know, permitted development rights can be removed by way of condition, so long as it is unambiguous. And increasingly we're having to look at specific conditions which were imposed on permissions which were granted before any of these much wider permitted development rights were imagined, and working out whether they serve to remove these permitted development rights to go from different uses to residential. We're also in a time where the courts have been changing their approach. Traditionally, the courts took a very narrow approach to interpreting conditions, looking closely at the form of the wording of the condition, so as to assess whether the wording precisely removed the permitted development right. Whereas now, in the last couple of years, we've moved to a much more purposive approach with the Supreme Court's judgments in the Trump case and the Lambeth case, which point to, you know, on one hand, more sensible approach, perhaps, where what the local authority surely intended is not removed just because they got the wording slightly wrong. But on the other hand, it's a more uncertain approach where you need to look at each condition very carefully. I'd also just note on the question of conditions. Conditions can, of course, be imposed on prior approvals. No doubt we're going to see more and more conditions attached to prior approvals. But the courts have held, there was a 2016 case, Pressland, that Section 73 applications can be made to amend conditions on prior approvals. So I think we're probably going to be seeing much more of that sort of activity. And then the last bit of my basket of issues is, you know, in what circumstances might you lose the benefit of prior approvals? There's one particularly unclear aspect of the GPDO, in my view, which is in relation to the PD rights involving new dwellings. The development has to be completed within 3 years of obtaining the prior approval. This really leads to difficulties because with change of use, what is completion? A strict approach might say actual occupation of all of the dwellings in the building, or do you take on board the Supreme Court's thoughts on implementation in the Welwyn Hatfield case, which we were discussing in a previous session, and I think, you know, that may be a line that, you know, you prefer, where implementation of a change of use could take place short of actual occupation. This is often a critical question for funders because, you know, it doesn't just go to, can I continue to occupy the bits of the building I haven't yet occupied? It goes to, well, do I actually have lawful use of those parts of the building that are already occupied? And then finally, to point out that the benefit of the prior approval can also be lost if there have been material alterations in the building between the prior approval and carrying out the development pursuant to it. And I just say that because it's quite topical, because there was a ruling from Mrs. Justice Lang last month in RSBS developments where that was precisely what happened. Prior approval was granted. The developer then, you know, carried out some extension works to the property, and it was held that the prior approval was no longer effective. So I hope I've addressed a number of questions people have asked without speaking quite too quickly.
Thanks, Simon. Yes, I think, you know, again, a lot of issues under that heading, and you probably go on for quite a lot longer to deal with a number of questions that we've had around that basket of issues. But drawing a line under that for the moment, I think it's time for us to turn to the new consultation paper and the proposal for the new PDR. And Victoria, perhaps you can kick us off with a bit of an explanation or a bit more detailed explanation around those proposals. And then I think you've also had some questions on those proposals already that you're going to address.
Certainly, yeah, thanks, Mita. Yeah, so the government launched a consultation on the 3rd of December earlier this month entitled, somewhat innocuously, Supporting Housing Delivery and Public Service Infrastructure. And the consultation runs until the end of January 2021. But don't be fooled by its name. It's fair to say that proposals have generated quite a reaction. A fellow panellist, Zach, no less, has described them as the most radical planning reform of the year in his recent blog post. And Simon, a fellow panellist, has compared the proposals to Einstein's theory of relativity with the apt description E=C3, the theory of residential rather than retail activity, which was rather good. So let's go back to the beginning. The new Class E was introduced into the use classes order in July 2020 and took effect on the 1st of September. And it formed an amalgamated commercial, business and service use class that includes the old A1 with some exceptions, A2, A3, B1, some D1 and D2. So that's all of those different uses amalgamated as one. And so overall, it's fair to say that there's a new empire in the use classes world order, and it's called Class E. And one of the key effects of amalgamating the old use classes with their individual quirks is that there's clearly no need for planning permission to switch between those uses. They're all in the same class, and that's simply not development. We all knew that more was to come. The introduction of Class E in September was accompanied by transitional provisions insofar as permitted development rights are concerned. So until 31st of July 2021, the existing PD rights are retained based on the old use classes that were in place prior to September of this year. And the government always said that new PD rights would be introduced at this stage. Hence this consultation on new PD rights, which is proposed to come into force on the 1st of August 2021 as the transitional provisions fade away. And in sum, the government is proposing to build on the introduction of Class E. So having facilitated the change of use between the uses within Class E, the government now proposes allowing this broad range of uses to change to residential. So the proposal is that simple, E to C3 as from the 1st of August 2021. And what are the ifs and buts? In short, not that many. The proposal is for a change from any use or mix of uses within Class E to Class C3 without size limit everywhere, not just on the high street or in town centres, even in conservation areas. The premises must have been in Class E on the 1st of September when the new use class came into effect. And there'll be the usual roster of matters for prior approval with which we've become familiar from the upward extension PD rights, other than a conservation area specific requirement, which Jack touched on earlier, for prior approval in respect of the impact of the loss of ground floor use to residential. The application process is fairly light touch. The government notes that the right would replace various existing PD rights allowing for the change of use to residential, including office to resi, which we've discussed already, and retail to resi. But that's somewhat underselling the proposals because they'll actually go significantly beyond existing rights, given the uses which are encompassed within Class E, e.g. restaurants, indoor sports centres, nurseries, creches, which would not previously have been able to make that switch. And the lack of size restraint is also quite significant as compared to existing size limits for retail and light industrial conversions, which are limited to 150 and 500 square metres respectively. And while PD rights don't apply to development requiring environmental impact assessment, you have to question whether that would really filter out many proposals, given that not many proposals for conversion of existing buildings would be likely to actually require this. So what's the thinking behind the proposals? Well, the Planning for the Future white paper published earlier this year is, as the name suggests, for the future. This is for the now. And that's what's quite striking about these proposals, and indeed the introduction of the new Class E earlier this year. The government is seeking immediate changes to deal with immediate challenges facing the country. And that double immediate is the government's emphasis, not mine. So supporting housing delivery is the main reason, with the government pointing to making the best use of brownfield development to support new homes, and the success, subject to a few light and space issues, of the previous office to resi PD rights. It also suggests that the new rights will boost town centres where there's a surplus of retail floor space, and they're considered to help to diversify and support the high street by creating new houses and bringing additional footfall from new residents who are co-located with town centre uses. And the reference to other locations in the consultation, not just town centres, is quite telling, because whilst the focus is on high streets, this applies anywhere. So retail parks, GP surgeries, gyms, places not necessarily found in the middle of the town centres, light industrial units. It's quite wide reaching. And what about the loss of retail, you might ask, and many of you have raised this as an issue. Well, you might well ask, it's notable that the existing Class M, allowing a change from retail to residential, includes a requirement for prior approval as to whether it is undesirable for the building to change to Class C3 use because of the impact of such a change, where the building is in a key shopping area, on the sustainability of that shopping area, and on the adequate provision of the services provided by the existing use. No such equivalent here, although there is this rather unusual, as Zach's mentioned, requirement for prior approval, specifically in conservation areas, in recognition, the government says, of the conservation value that retail frontage can bring to such areas. And so the right would allow prior approval of the impact of the loss of the ground floor use to residential, but only in such areas. And as Zach has mentioned in his blog post, this is quite an interesting idea because it sort of implies that a retail frontage tends to bring less value outside conservation areas, and designating the conservation area in the first place may not have had anything specifically to do with the vitality of the ground floor retail offer. We've had a number of questions on this topic. One of them is predictably perhaps about how this might be stymied by the imposition of conditions which would disapply the benefit of the GPDO, so this new right, and even the use classes order, so the ability to switch between the different different uses within class E. And I think Simon has really covered that point. So there's both the issue of existing conditions disapplying the right, but there's the ability in the future for the LPA to stymie the use of such rights, which would also be possible, perhaps given some ammunition, but by the cases, albeit it's important to note that the planning practice guidance, which does inveigh against a broad brush approach to conditions, requiring them to be focused on tackling specific problems. So it does warn that any condition which on a blanket basis disapplies PD rights or the effect of the use classes order may not pass the test of reasonableness or necessity. I've also been asked in general what issues we perceive with this, and I'll allow Simon and Zach to chip in as well, given that they've already written a lot about this. But I think it's important not just to focus on the negatives. I mean, we're undoubtedly living in a time of great change on the high street. The government has studied and studied and studied this. There have been no ends of task forces, consultation, and independent reviews. And there's certainly a case to be made for flexibility and the ability of town centres to be responsive and adaptable. Towns are places where we live and work, and I suppose the thinking is that the more we live there, the more high streets may be able to work. However, as I see it, that there's a risk that the proposals perhaps take the planning out of town planning, and indeed there are a number of local development plan policies which are designed to control the location of particular uses, which become rather anachronistic as a result of these various changes. There's a lack of control at the LPA's disposal to ensure that we end up with the right homes in the right places, a familiar tagline. Do we want them in the core of town centres? The consultation sets out the proposed list of matters for which prior approval would be required under various subheadings, and there's interestingly only one under the subheading to ensure new homes are in suitable locations, and that is the impact on the intended occupiers from the introduction of a residential use in an area the authority considers is important for heavy industry and waste management. So unless new homes are proposed outside an area considered appropriate for those purposes, the right is location blind, and it's not even game over if it's residential use in the middle of an industrial heartland. And I think building on what Zach has said, as the PD rights become more and more expansive in terms of their application, there's a question mark over the weight carried by the prior approval process, and indeed the lack of any mechanism to secure planning obligations, and given the residential focus in particular, affordable housing contributions from these schemes, which may be somewhat anomalous given that there could be similar sized schemes, albeit ones requiring planning permission, which would be subject to such obligations. So that's just a few potential issues. No doubt others have more to say as well.
Yeah, well, thanks, Victoria. I was just going to point very quickly to the areas where, the new permitted development right is wider than existing rights, and maybe that divergence is the area where the government will be looking carefully at how people respond through the consultation process. So number one covers a wider range of uses, restaurants, indoor sports venues, creches, etc. Will all be able to convert to residential. Secondly, scale, because there's never been any scale limit for office to residential, but there's been a very low scale limit for retail, which is 150 square meters, very low scale limit for light industrial, 500 square meters. Then conservation areas, the new right will apply. The office to residential right applies in conservation areas, but the other rights don't currently apply. Light industrial, at the moment, the whole building has to be in light industrial use in order to take advantage of the change, and certainly that's been an issue on a number of cases I've been involved in. And then, lastly, by way of example, at the moment, office use, the building has to have been in office use as at 29th May 2013. And presumably that date is going to be rolled forward to 1st of September 2020, which will bring a lot more buildings potentially into the scope for use of the change. So, those are just some of the ways in which this new right will be much wider than the existing rights. So
it's so interesting. I mean, I've got very little to add to what Simon and Victoria have said, but I was rereading the Portis review for the purposes of writing my blog post the other day from 2011, and one of the things that she picked up on, and a theme of her report, was that the use classes order as was almost a decade ago was a sort of major impediment to the flexible development of the high street. And boy, oh boy, obviously she couldn't possibly have anticipated that the full range of changes, even in the last 6 months, let alone 10 years, that our high streets are facing the challenges as never before that they're facing. So, we shouldn't underestimate the value of flexibility, the value of allowing developers in the centre of our cities to be flexible, to fuel the economic, cultural, and social heart of our cities. But on the other hand, as Victoria said, it raises fascinating questions about how our local planning authorities to actually go about the business of planning, with such sort of limited tools in their toolkit. Once you move outside of Article 4 directions, as Simon talked about, pretty blunt instruments as they can be, and indeed planning conditions, something Victoria touched on. Not much left, if in terms of development management functions, if you add Class E to the proposed development right to take it into C3. And indeed, just a final sort of thought from my end anyway, is such an interesting thread to see how, or to contemplate how this limb of the government's thinking about speeding things up, flexibility, pushing through lots of new homes in the middle of cities through prior approval, PD, sits alongside, or perhaps doesn't sit so well alongside, the threads in the white paper about the focus on design, on quality, on local vernacular, and all that stuff about Bath, Belgravia, and Bourneville that we've been talking about in previous webinars that I know Mita enjoys so much. How, if at all, will these new residential schemes through the proposed new PD rights sit alongside or contribute towards meeting those objectives in the white paper? It's a brain teaser. I don't think there's an easy answer, but it does seem to me to suggest there's two threads in government thinking that aren't necessarily pulling in the same direction. That's it from me, Mita. Back to you.
Thanks, Zach. Yeah. Yes, this is going to be interesting, isn't it? I mean, I probably don't have anything to add either. I think the thing that I find interesting is, the way that the paper introduces the new proposals is, it's what you all just talked about. So it emphasises housing delivery, but then there's this other emphasis on the high street and town centres, etc., etc. But the issue is that town centres and high streets are so different, across the country, and it's this sort of blanket approach, I suppose, to addressing what they see as the issues here, in particular housing delivery and vibrancy of those areas. And the way that this is going to work in different places is very, very different. It's something that we've already seen with the Office to Resi rights when they came in, and the one thing that doesn't seem to have happened here is that there's any acknowledgement of that. There's this sort of emphasis on repurposing. There's an emphasis on thinking about surplus retail space, as though there's surplus retail space everywhere, as though there's lots of vacancy everywhere, and there are lots of buildings sitting around vacant everywhere. That the reality is that's true, but it's not true of everywhere. And so what you're going to see, I think, is what we saw with the office, well, the office to resi PD rights. In some places, those PD rights will have a really great effect. They'll be doing something beneficial in the areas where there are sort of vacant buildings that have been sitting around forever. But in other places where that's simply not what's going on, you're going to see a pepper potting, I think, of uses with these residential uses inserted into places where you would never have expected them before, simply because resi has better values than retail. I suppose the other thing to layer into that, and to be fair, is the fact that we have, we're in the middle of a global pandemic, and so to a certain extent, it would be fair for the government to be thinking about what might be coming down the pipe in the future, which is, this sort of not across the board, not just with retail, but this sort of grand sort of reshifting and restructuring of how we use our places, and where we're going to have the focus of office space and retail space, and moving away from everything being very centralized, and people basically having more of an emphasis on the places where they originally lived, but now will live and work. But yeah, all very interesting times. Just one eye on the time. I think we're almost at the end of our hour. Perhaps we should just go around and pick up on any sort of final and concluding comments from the session as a whole, actually. Zach, can I pick on you first?
Thanks so much. It does seem to me that we are genuinely at a tipping point. And I don't want to be hyperbolic about it, but obviously the white paper and the mutant algorithms and all the rest of it have swallowed up the headlines this year in relation to planning and proposed reforms. And really, the public focus has been on housing. Let's just be honest about it. Housing numbers, zones for housing, how housing is going to be distributed across England, and all of that, which is obviously very important stuff. And the ministry is working through 44,000 odd responses to the white paper. We're going to get in early in the new year, we think, the response to the consultation on the standardised housing method and all the rest of it. But actually, the topics that we've been covering tonight, I think, are in some ways the biggest headline, because they've already started to happen right now, as a point that Victoria made earlier. It's not about planning for the future, not this bit. This bit's already in force. And, the consultation that we've been describing to take it from Class E to C3 is obviously ongoing. And so I suppose my final thought is that those who are still watching this evening with an interest should, get out your consultation pencils or whatever and get writing, because it's really important now, whatever side of the fence you find yourself on the benefits or not of these ideas, that the ministry gets a good cross section of opinion.
Thanks.
Thank you.
Victoria.
Yeah, thanks, Mita. In some ways, I think you have to applaud the government for its creativity to some extent. The thrust of the changes is to try and deliver more housing, and that's clearly an absolute priority. And how are we going to go about it? It's not easy. It's not quick on greenfield sites. It's easier to build on what we've already got, or to get rid of something redundant and put something new in its place. And so the intention, I appreciate. The difficulty is, as I think Zach put very well, was writing development management into law, and the questions that we've had, which have been plentiful. This has generated such a debate for this webinar, have really highlighted the difficulties in interpretation of some of the conditionality in the legislation, and that's because it's not easy to prescribe in legislation what should be given planning permission. We have a planning application process which you apply for, and it's not stipulated as to what the output should exactly be. Permitted development sort of works backwards. It tells you what you can do, and there's so much variety. There's so much scope for things to be different, and the questions that we've had, this isn't a call for lawyers, but they are points of legal interpretation. And so these rights, whilst they're designed to be quick, easy, let's get on, let's build, let's extend upwards, there are all sorts of devils in the detail. and extreme care needs to be taken in bringing forward these proposals and ensuring that that they fall within the legislation. And in many cases, as I think the questions we've had have demonstrated, that is not an entirely clear question. That's all I was going to say. Thank you.
Thanks, Victoria. Simon?
Yeah, well, sorry, Mita. Yeah, I'd certainly echo that in terms of the balancing of considerations which takes place in the consideration of a traditional planning application is properly in the role of planners. And the unfortunate thing about the GPDO is it moves issues into a legal context. And I've been looking at the questions we've been asked and trying to categorize them, because there's many that I'm conscious we haven't answered, and they arise, I think, mainly from three different perspectives. First of all, the reality is there are physical constraints in buildings, which mean it's often not straightforward to use these permitted development rights. So you do need to bring forward applications to introduce fenestration, cladding, to maximize the use of the building through extensions, how you deal with car parking, entrances, and the interaction between the planning application and the prior approval takes, if acting for the applicant, takes a careful consideration of strategy when the Class E new permitted development right suggests that floor plans showing windows should be provided with your application. Well, if this is trying to make use of a redundant department store that currently has no windows, that is difficult when you're going to have to do that, the fenestration through an application. So first of all, physical constraints. Secondly, the conditions and limitations on all of the permitted development rights are so multifarious, but still do not reflect the almost infinite permutations of configurations of buildings, because the questions we've been asked are very specific about balconies on upper stories of buildings, upper stories that are added to buildings, and whether the balcony is means that the permitted development right doesn't apply because the footprint of the building is going outside of the existing building. What is a terrace? What is a detached building? These are issues which really are almost incapable of being defined comprehensively in legislation without arriving at something like the SIL regulations. And the third category is the operation of the prior approval process and the inevitable subjectivity of that, and how appeals are to be determined and are determined with any sense of certainty being given to those who are going into that process, whether local authority officers or applicants. And so by way of apology for not answering all of the questions, I think it's because there is an almost infinite variety of issues which are arising because life is complex and the built environment is more complex than legislation can cater for.
Thanks, Simon. And just in case anyone is in any doubt, although we are all lawyers, I don't think that Simon or any of us are advocating for the PDRs to become any longer than they already are. So on that note, we have actually got to the end of our hour and we've run over slightly, so apologies for that, but this seems like a good place to wind up the session. Thank you very much to the panel, and then thank you also, and more particularly to all of you listening in. Hopefully we've turned around and turned upside down some of the issues that have been taxing you on these PDRs and made some of it all clearer, but then also no doubt raised a lot of other questions that perhaps you hadn't even thought about before. But some of those are for another day. And now it's very definitely wine o'clock. So goodbye and look forward to seeing you at our next webinar in due course.
No, thanks, Peter. Thanks, everyone.
Thanks. Bye.